That can be very effective because I had one where the person transferred everything to his spouse. She happened to be a dentist, and I said, just summons, the spouse to come to court. She'll have to give up an entire day to sit in court all day, and I suspect that she'll just want to pay off the judgment and then deal with her spouse after.
I wanted to ask you about garnishment hearings. Do you see many sort of disputes surrounding the garnishment, that the financial institution is sort of coming to you for instructions or that sort of situation? Could you sort of go into that?
The biggest problem with the financial institutions is the people don't have the correct name on the account. And if you don't have the correct name, the bank won't honor the garnishment. So you've got to do your searches, you have to ask the questions at the judgment debtor examination to make sure your garnishment is correct. The banks won't honor it if you don't have the correct name. The other problem is, of course, when you have a joint account. And usually for a joint account, you can only, if the account's 50-50, you're only entitled to 50% of the money, regardless of who put the money in the account.
Okay. RRSPs, my understanding is that's a little bit ambiguous in terms of whether you can go after that.
It is because of the mandatory withholding tax from the government. Often banks won't give you the money from the accounts because they feel an obligation which would make them liable if they don't pay the withholding tax.
Okay, great. And the small claims court is unique in that you have these consolidation orders, the textbook talks about them, but in terms of the actual practice, perhaps you could sort of tell us about why that exists and whether you see much of that?
We actually see very little. The rules, I think it's 20.09, provide that a debtor can apply to the court, get all their debts consolidated into one monthly payment. It doesn't cost anything, unlike people that advertise in the papers that they'll do it for you, but they charge a fee for it. The court basically does it for free, but unfortunately what happens is there are two circumstances where that consolidation order ends. If the debtor doesn't pay the monthly payment, or if the debtor runs up additional debt after getting the consolidation order. So it's used very infrequently in court.
Okay. My final question, if I'm appearing in front of Judge Libman and I'm a licensed paralegal, at any of these enforcement proceedings, can you tell me what you're looking for from me? I know that my performance is sort of critical in terms of both the written advocacy and how I'm appear in court.
Well, if you're acting for the creditor, I'm looking for you to get the right questions. Where do you do your banking? Where do you work? What kind of assets you have? Get right to the point, because there are a lot of cases that we deal with at the same time. If you're acting for the debtor, then you should be advising your client that if your client disagrees with the judgment, usually they're default judgments, bring a motion to set it aside. If you say to me, as a licensed paralegal or licensed representative, I intend to bring a motion, I'm going to proceed with the judgment debtor exam. On the other hand, if you say to me, we have a date in 2 weeks for a motion to set it aside, I'll adjourn it. And usually I adjourn it to the same date as a motion. So do your job, understand the rules, and that way the examination will go very smoothly.
Okay, thank you very much. This is great. Thanks.